We're so glad that you're ready to execute the estate plan we prepared for you. Now that you have scheduled the signing appointment with one of our attorneys to sign your estate plan, we'd like to go over some of the tasks you need to do after the documents are signed. These are very important steps to ensure your trust is properly funded, because funding a revocable trust is as important as creating one. This video provides the critical steps and advice to ensure you successfully fund your trust. However, please be aware that the instructions I'm about to provide are not all-inclusive. Some special assets, such as shares in closely held corporations, LLCs, as well as mineral rights, may require unique circumstances. Please don't hesitate to ask us to better explain these special circumstances at the signing meeting. To avoid probate, minimize estate taxes, and best direct your assets to your intended beneficiaries, it is very important that the revocable trust be properly funded during your lifetimes. To obtain maximum benefit, you should transfer your property to the revocable trust as soon as possible. However, please note that you should not transfer ownership of any retirement accounts and/or annuities to the revocable trust. These types of investments should remain outside of the trust to avoid unintended income tax consequences. Even though your retirement accounts and/or annuities will not be owned by the revocable trust, probate can still be avoided as long as the beneficiaries are designated for these accounts. For your retirement accounts, please verify the beneficiary designation. Make sure you have designated the primary and secondary or contingent beneficiaries. If you have minor children, we recommend you designate the trust as the beneficiary instead of the minor children. Keep in mind that the person you designate as the beneficiary will be directly receiving the funds in his or her accounts. If you are married and your spouse is not the primary beneficiary, California law requires you to get your spouse's consent. To see a sample of the beneficiary designation form, please visit our website. First, if you own one or more real estate properties in California, our office will record the grant deed to transfer the properties to your trust. Once that is done, you should receive the recorded deed in the mail in about 4 to 8 weeks. It will come directly from the county recorder's office. As a result of recording the grant deed, please be aware that you may also receive multiple solicitations in the mail during this time. These solicitations may ask you to pay to receive a copy of the deed. While they may look very official, please disregard these solicitations. The official letter will clearly state it is from the county recorder's office. Regarding your vehicles, it is generally not advisable to transfer ownership of your automobiles, recreational vehicles, and boats to your revocable trust. Please note that any and all vehicles are referred to in this paragraph simply as vehicles. Transferring the title of your vehicles can easily be accomplished after death without the need for probate. However, if you do wish to transfer the title of your vehicles to your revocable trust, I advise you to seek assistance from the Department of Motor Vehicles by visiting one of its field offices or logging on to dmv.ca.gov. As for your financial accounts, you must change the name on every account that you wish to be owned by the revocable trust. This includes each bank, brokerage, money market, credit union, or mutual fund account you may have. However, it is not necessary that all of your accounts be transferred to the revocable trust if the total amount of property outside the trust is less than $150,000. That's because under California law, each person may have up to $150,000 of personal property in his or her own name upon death and still avoid probate. In fact, this amount of property may be claimed by affidavit up to 40 days after death without the need for a probate administration. There's an important reason why all of your accounts should be transferred to the revocable trust. If you unfortunately became incapacitated or disabled, any property outside the revocable trust would need to be handled by an agent acting under a power of attorney, who may not have your best wishes in mind. It's possible that the power of attorney may not be accepted by a bank or brokerage account, or that all agents named in the power of attorney will be unable to serve. In such a case, a court order would be needed to access the funds. For the financial institutions that have local branches, here are the steps I suggest. First, talk to someone responsible for new accounts at your bank, or simply talk to your private banker. Next, ask to have the title on your account or accounts changed to the name of your revocable trust. If your revocable trust names more than one trustee, you should point out that any one trustee may transact business on behalf of the trust alone. Therefore, the signature card should only require one signature for bank transactions. If the bank allows it, ask to keep the same account numbers on all of your accounts. Also, request that your checks remain printed as they are so they do not include the name of your revocable trust. While featuring the name of your revocable trust on your checks will not cause you any difficulties, any person or business you write checks to will now know you have a revocable trust. Third, the bank may want a copy of your trust agreement. If they do, tell them you would prefer to give them a copy of your certification of trust instead. Your certification of trust also features the proper name for the account, and the trustees have authority to open this type of account in the name of your revocable trust. Rather than accepting the certification of trust, the bank may still require a copy of the entire trust agreement. If this happens, ask if they will accept the first as well as the last 2 pages, because the other pages are of a personal nature. Most bankers will understand and oblige. However, if they insist on needing a copy of the entire trust agreement, you have 2 choices. You can either provide it to them or find a different bank that does not require an entire trust agreement. Finally, you'll need to sign the new signature cards. Please note that you should not have to use the word trustee as part of your signature. Out-of-town institutions. If you have a bank account at an out-of-town financial institution, you will need to contact them by phone or email. They may also want a copy of your trust agreement. If they do, tell them you would prefer to give them a copy of your certification of trust. Again, the bank may not accept the certification of trust and still require a copy of the entire trust agreement. If this happens, I advise that you ask them to accept only the first page and the last 2 pages, because the other pages are of a personal nature. If they insist on needing a copy of the entire trust agreement, either provide it to them or find a different bank that does not require it. When you receive the new signature card in the mail, make sure the revocable trust is properly listed as the owner. If it's correct, simply sign it and send it back to the institution. Again, you should not have to use the word trustee as part of your signature. If you have a brokerage account held by an out-of-town firm, you should call your broker's toll-free number to find out exactly what steps you must take. It will likely be necessary to have your signature guaranteed. That can be accomplished at most major brokerage offices or at certain commercial banks or trust companies. Ask your local bank or brokerage firm if they provide this service. Please note that it's best to have a medallion guarantee instead of a regular guaranteed signature. The brokerage firm will tell you what additional forms will be needed for a medallion guarantee. Yes, there are some banks and credit unions that do not allow their customers to open revocable trust accounts. If you're told you cannot open a trust account, simply ask a more senior bank officer who may be more familiar with their policies. However, if it turns out that you are definitely not able to have a trust account, you have 2 choices. The easiest choice is to find a bank that does offer trust accounts. Or you can set it up as a joint tenants with rights of survivorship account or as a payable on death account. This way, the account will pass directly to the surviving joint tenant or to the named beneficiary without having to go through probate. Please keep in mind that if an account does pass directly to a person, it's possible that the planning contained within your revocable trust may be nullified or disrupted. Most financial institutions will happily change the certificate owner to a revocable trust without any penalty. However, if your financial institution will impose a penalty, you may want to wait until the certificate of deposit matures before changing it to your revocable trust. In addition, it's important that your certificates of deposit qualify for FDIC or FSLIC insurance coverage. Check with your financial institutions to ensure all of your certificates of deposit have been properly styled in the name of your trust to qualify for this insurance coverage. If you maintain a safe deposit box, you may want to change the registration to your revocable trust. By taking this step, you may avoid a probate proceeding following death, which would otherwise be required to open the box if no alternate person is named. As we mentioned earlier, for assets such as U.S. Treasury bonds, business interests like LLC or partnerships, mineral rights, paper stock certificates, or leases, there are special circumstances. We will gladly address these with you individually during the signing meeting. Again, we appreciate you taking the time to learn about how to successfully fund the trust. We'll be happy to answer any questions you have in our next scheduled meeting. As always, thanks again for choosing the law offices of Connie Yee as your trust administration attorney.